On August 9, 2008, a forum organized by the Malaysian Bar Council titled Conversion to Islam, Article 1211A of the Federal Constitution, Subashini and Shamala Revisited, was cut short by a group of angry Muslim NGOs. They gathered at the Bar Council building and ended a seemingly innocuous forum to discuss the plight of spouses facing divorce and annulment of marriage by the conversion of one party into Islam.
Sesungguhnya kita tidak pernah untuk menggugat kestabilan agama orang lain. Maka kita harap juga pihak-pihak lain jangan cuba untuk menggugat agama Islam dekat kita ini. Belajar lo tapi tak tahu undang-undang. Bincang, kepala otak lah bincang.
So what brought about so much anger?
Pertamanya kita membantah keras forum ini kerana forum ini mempertikaikan kedudukan Mahkamah Syariah yang telah diperuntukkan dengan jelas di dalam perlembagaan di bawah Artikel 1211A, dan keputusan Mahkamah Persekutuan sendiri di dalam kes Azli Najala ini telah menyamatarafkan Mahkamah Syariah dengan Mahkamah Sivil dari segi bidang kuasa masing-masing. Kecubaan Majlis Peguam hari ini untuk mengupas kes Subashini dan Shamala menunjukkan mereka tidak menghormati keputusan Mahkamah Persekutuan dan tidak menghormati langsung peruntukan perlembagaan persekutuan. Dan yang lebih parahnya, ianya telah mengguris perasaan umat Islam.
If you look at it, what is Article 121? Article 121 basically states what is the jurisdiction of the civil courts and what is the jurisdiction of the Sharia courts. And it says that if a matter is in the jurisdiction of the Sharia court, then the civil court does not have jurisdiction. That's all it is. And for many years there was no problem with that. Yeah. So the next question is, what is the Sharia court's jurisdiction? That is also determined by the Constitution in Schedule 9. There's a list which says that the Sharia court deals with these matters. So as long as the issue is within that list, then the civil courts have no jurisdiction, and nobody is disputing that. I don't think the forum was disputing that.
1A says that the High Court shall have no jurisdiction in any matter within the jurisdiction of the Sharia court. So the intention at that time was to just make sure that Muslims who had gone to the Sharia court and were not happy with the Sharia court decision couldn't then hop over the fence, as it were, come to the civil court and take a second bite at the cherry. Now that was the reason why 1A was put in, and that was fine. On its words, on its plain meaning, 1A is a innocuous provision. However, what happened in the late 90s is the courts started interpreting 1A in such a way that it sort of began to elevate the Sharia courts, and until you came to a point where in some cases judges were saying the Sharia court and the civil court are equal, or that they are parallel court systems. Actually, we only have one court system. We have the Malaysian, a judicial system. The Sharia courts are a specialized court dealing with very specific matters. And so if it was interpreted the way it was intended, it would not cause any problem. The problem is coming because people are trying to argue, and the courts, unfortunately, in my view, allowed them to say that the Sharia court was larger than what it was intended to be. Very recently, the federal court has made a decision called Latifa Madzin. In that case, they very clearly said the Sharia courts are courts of limited jurisdiction, and you have to look to the state law that created the Sharia court to see whether they have a jurisdiction over any matter. And the federal court emphasized, and they have repeated this recently in another case of Haji Kaha, the civil court is still, the High Court is still the constitutional court, the court created by the Constitution. And implicit in those decisions is it is superior, but I should explain that it's superior in the lawyer's sense, in that we have one decision maker, which is the Civil High Court, which is for all Malaysians and is subject to the federal constitution. Sharia court doesn't mean it's when we say inferior court in layman's terms, all it means is it is subject to oversight by the High Court. It doesn't mean the Sharia court is inferior in the normal English language sense. It's not a less perfect court. It still dispenses justice. It's still meant to, just the same way that magistrates court, sessions courts or the industrial court. So in that way the Sharia court is a court and it should be respected, its judgments respected. But what the federal court said is it must act within its boundaries, which are set by the constitution.
One case that was to be discussed was Subhashini versus Saravanan, and the issue surrounding this case needs to be understood before the bigger issue of Article 1211A can be appreciated.
At that material time when Subhashini filed her petition, she filed an application to ask the court to restrain, the civil court that is, to restrain Shafi Saravanan from continuing with the Sharia applications in the Sharia court. So that was the crux of the matter. Yeah? So the whole background of the proceedings in the High Court, the Court of Appeal and the Federal Court was with regards to this application, which is the application by Subhashini to stop Saravanan from continuing the proceedings in Sharia court until her petition is heard first. You see the picture? So that was it. So there was no discussion yet with regards to the divorce. There was no discussion yet with regards to the factual allegation by Saravanan or by Subhashini. We did not go into that yet. Neither did us, nor did Subhashini's lawyer, and of course the court as well. It was purely on that issue of whether the civil court should or could grant an injunction to restrain Muhammad Shafi Saravanan from continuing with his Sharia proceedings.
The Subhashini case is still not over. It is pending hearing in the federal court for a review of its earlier decision.
Because when we go to the federal court, we go by way of questions posed to the federal court. We can't just go and appeal against everything in this Court of Appeal. To clarify, if I can take you back to the High Court itself. In the High Court, we won. Saravanan got the order to dismiss the application. In other words, Subhashini cannot restrain his applications pending in the Sharia court. Now, at that juncture, Subhashini appealed to Court of Appeal. But because the urgency of the matter was quite grave, she asked the High Court to stay that order. That is where the Erinford comes in. What does it mean? It means that, okay, even though the court says I cannot stay, I cannot injunct Saravanan, but I want the court to please allow me to injunct temporarily until my appeal is heard by the Court of Appeal, so that there's no damage done. That's what she claimed, and the court granted the Erinford stay. So at the Court of Appeal, there were predominantly two appeals. One was her appeal against the decision of the High Court dismissing her application for injunction, and there was our application, or rather sorry, our appeal against the granting of the Erinford appeal. So when the Court of Appeal heard, the majority of 2-1 again dismissed her appeal. Said no, you can't injunct Saravanan from continuing with his Sharia proceedings. Yet also they agreed that our appeal should be allowed, which is that the court should not have granted Erinford. However, they then granted an Erinford, a further Erinford, to stay their own order until the federal court heard Subhashini's final appeal.